I want to tell you about a file that crossed my desk not that long ago. A family had lost someone they loved. It was a will, and they'd found it. It was signed, and it looked good to go. They thought they were in good shape, and it was a relatively small estate. So they went down to their bank, and when they showed it to the people who worked there, they were told, sorry, we can't work with this. What happened? They had an executor, they had a document signed by the deceased, but the bank still wouldn't deal with them. They tried another branch where they knew people, and the manager there explained in a little bit more detail that this was not a will the bank could rely on. Weeks went by. Bills piled up as the family wondered what they were going to do and who they could reach out to for help. They couldn't even find out what was owed and to whom because the banks wouldn't give them any information. But what had gone wrong? Well, it turned out the will had been drafted from an online template. And this template, for all of its neat formatting and official-looking language, had not given the executor any powers. Not the power to access accounts, not the power to deal with property, not the power to do much of anything. And further, it was not signed by two witnesses, just one. And that witness did not provide an affidavit of witness. Well, the family eventually had to go to court and obtain an order from the court. They needed to file a full court application as if the person had died without a will at all. This was a pre-order that allowed them to go to the banks and so forth. It cost them legal fees that they hadn't budgeted for. It cost them weeks of delay. And because the banks wouldn't show them the records during that delay, they didn't even know what pre-authorized payments were coming out until an overdraft was already present. The will existed, it just didn't work. I'm Chad Graham. I'm a lawyer in Edmonton, Alberta, and this video is meant to present general information about estate planning. I'm going to answer some questions and answers over the next few weeks that I think will be helpful to you, but if you have specific issues from your life, you want to consult your own lawyer about them. Let's break down what actually happened in this case of the will that was a no-go. What actually happened? To understand it, you need to know a little bit of something about how wills work in Alberta and how banks and financial institutions decide whether to release funds to an or information even to an executor. So a will is a legal document, and it empowers the executor to do what is in the will. But it is only as useful as the authority it actually grants. And in Alberta, most financial institutions won't move until they're satisfied the executor has the legal authority to act. That means they may need a grant or order from the court, or a will that is clear and complete that the institution is comfortable relying upon it. A document with gaps, especially a document that does not empower the executor to deal with the bank, or a document that is not properly executed or signed, will trigger this kind of problem. Now, under the modern surrogate, that's the estate court's rules, you can cure most faults and get orders that will fill any gaps that come up through a court application. But that's just the problem. It takes a court application. It takes time. It costs money. And it is in every practical sense putting you in the same situation as if you didn't have a will at all. So what's the point? That's why I wanted to talk a little bit about through some of the myths that lead people to do DIY wills and look at where you might actually find one valuable. The first myth is, hey, a will is a will. As long as I write it down and sign it, it'll work, right? Now, this is an interesting one because Alberta does recognize what are called holograph wills. Those are all handwritten by the testator, the person writing the will, and signed by them. A will written entirely in your own handwriting and signed by you does not need witnesses. So the formal bar is very low. But a holograph will still has to clearly express your intentions, still has to appoint an executor, and still has to give them at least sufficient powers to deal with things. I actually had one come across my desk that said, I leave everything to my wife, sign so-and-so. Well, it did designate that everything was to go to their wife, but it didn't name an executor, it didn't give any powers, and boy, it didn't quite get the job done. But because the wishes were there, it was clear what should happen to everything after the fact, after the court had gotten involved. You know, in the case I started with, it was interesting because they had a really good looking will. It was done from a template that was very professional looking. I think it might have been one of those ones online where you sort of fill in the blanks and it flushes out the will for you. It looked pretty good. It gave an executor up top, but the person who filled it out didn't know exactly what to ask. Maybe didn't select some of the things they needed to select, and because it wasn't reviewed by a lawyer, there was no one to look at it and see whether it was going to work. It was signed. It was witnessed by one person. It just didn't do the job. So a will is not just a will. The second myth that I hear a fair bit is the myth that the bank will just work with me to figure this out. A lot of people go into the bank with the expectation that their banker, even the one they've known for years and years and years, will just work with them and sort something out. Banks aren't going to do that. This surprises so many people, but the bank's job isn't to interpret a document and or to do what seems reasonable. Their job is to follow national policies, which are designed to protect them from liability. Imagine somebody coming in with an older will that was kind of incomplete and showed them as an executor, and they said, hey, give me the $100,000 that are in the account, and the bank cut a bank draft, and off they went. And a week later, an executor came in with a 2-year-old will, done complete and proper, all witnessed the way it was supposed to be, and empowering that executor to deal with the banks. And they said, hey, we're here for the $100,000. And the bank would go, oh. An incomplete will never get the benefit of the doubt. It gets referred to legal compliance, and legal compliance will say no. Now, in the file I just described with the $100,000, the bank is going to require you to go through probate anyway, but they'll at least give you the information that you need to help complete that probate process and to make things smoother if you have a will. A smaller figure in there, a bank will often allow the executor to sign an indemnity and move away with it right away. But that's a little bit up to their internal policy. Myth 3, it saves money. I get it. I can be a cheapskate too. I hear this all the time. Oh man, why would I spend money on those lawyers to get this done when I can just do it myself? Why would I spend money on a marketing firm when I can just do it myself? Why would I spend money on a secretary when I can just type this up myself? Doing it myself doesn't always save money, as I've found in many realms, and you probably have too. Sometimes it does save money, but then the question is, what is your time worth? You see, a court application involves legal fees, court costs, and time. Time that can cost interest, missed payment fees, and other complications. In that file I described at the beginning, those costs far exceeded what a lawyer-drafted will would have cost by a significant margin, I think a factor of 10. And that's before you count the financial losses from the delay itself. While that's true, not everyone needs an elaborate estate plan. But we need to look at the math. I'll save money doing it by myself and ask, what is my time worth? And what are my mistakes worth? If I don't understand this, what could it cost me? The fourth myth, hey, online templates have been reviewed by lawyers, so they must be fine. Oh, this one is so frustrating. Some of the marketing is a little bit, in my view, kind of misleading. Alberta has its own legislation governing wills. It's very particular. It's called the Wills and Succession Act. Some of the rules in Alberta are different than in other provinces. Each province has its own act governing what their wills look like. So even a good general written template that has been drafted by a lawyer is just giving you a basic framework. It's giving you a huge help. And if you do very careful research and you spend your time on it, you could probably figure it out. But is that how you want to spend your time? A template written that way may not reflect Alberta law specifically, and you'd have to dig into that even to get started. More importantly, a template can ask you questions. Good as it is, it's not the fault of the template. It doesn't know that you own a business or that you had a child from a previous relationship or that your named executor lives in another country. The document it produces is generic because it was designed to be generic. Your estate might not be. Okay, so when is a DIY perfectly fine? I want to be real straight with you here. Sometimes I think the legal profession overstates its irreplaceability. There are very much situations where a competent, generally educated person who works hard at it could draft a self-draft will and be perfectly fine. I've seen some. Especially if you're like a single person with no business, no blended family, modest assets, and clear and simple intentions. Why not? You could do a holograph will. You could do a template will, but make sure you get it properly signed. Whatever it is that you do, I think you really legitimately could figure it out. So I'm not here to tell you that every Albertan needs a lawyer for every document. But there is a gap between this looks like a will and this works like a will. And if you don't know what the difference is, that's probably when you need a lawyer. Most people who come to me after a DIY has failed, they thought their situation was simple too. I've had children come to me and roll their eyes and say, "Oh, this is so like Dad. He thought he could do it. You should see what he did to the XY in the basement." You know, some people are different. It's just the way it goes. We got to have a little laughter and fun with it and move on the best we can. If you're in the situation where you've had a DIY go south, come talk to me. Maybe we can get it sorted out. If you're in a situation where you thought your DIY was good and now you're thinking about it again and you want to make sure children are well taken care of, let's talk. We'll get you all sorted out. A will is not just a document. It's an instruction set for the people you love for the hardest days of their lives. When it works, they never have to think twice about it. Your family will be taken care of. They just follow it, they grieve, and they move forward. When it doesn't work, they spend months in legal processes they didn't expect, spending money they didn't plan to spend, while they're already carrying more than anyone should have to carry. The person that I started this episode with didn't have a bad will because they didn't care. They had a bad will because the template they used and trusted just didn't ask the right questions. A good estate plan starts with a good conversation about your family, about your assets, about your intentions, and what you actually want to happen. That conversation is what I do. And I've distilled this conversation into a web app which walks most people who have a simple estate right through to getting all the information I need to draft your documents. If you have questions about planning or a more complex situation, business ownership, multiple marriages, children from other marriages, then probably you don't want to go through the web app. You want to talk to me directly. But you can go through the web app or you can book a conversation with me through my website, jaggrahamlaw.com, or find a lawyer near you. And we'll see you in episode 2.